Welcome, everybody. We're going to start. We're welcome to Senate Economic Development, Housing, and General Affairs. It's good to have you all with us. Lots of new faces. So it is, what day is it? It is Wednesday, April 22nd. And today we're turning our attention to two consumer protection bills, our data broker bill, and our ticket resellers bill. So I think given all the new faces we have in the room, and Rick, I keep feeling like I've seen you. We've met before, and I think with me, but anyway, you're just such a familiar face. Let's introduce ourselves, and then we'll start.
Good morning, Dave Williams, representing Rutland County.
Randy Ross, Franklin County in Northern Grand Isle.
Allison Clarkson, Winter District.
I'm Tom Chittenden. I represent the southeast area of Chittenden County and Keysharon Hits Hills from the same district.
And she should be joining us at some point. And we welcome everybody on the line as well. And Tracy, we're going to start with Tracy Laughlin, who we have online. Welcome. It's good to have you.
Thank you. Yes, it's good to be here. Can you all hear me okay?
We can hear you. We can even see you.
Excellent. Great.
I know. That's astonishing.
Yes.
Welcome. Introduce yourself and go for the doctor.
Okay. My name is Tracy Laughlin. I'm Managing Director of Privacy and Government Relations at the National Student Clearinghouse. I really appreciate this opportunity to speak to the committee today about H211, the data broker bill. Should I go ahead and dive in?
Dive in.
Okay, great.
Tell us what you do. What does National Student, what do you do?
Yes.
What's your company do?
Yes. Well, that is where I was going to start. So
Right.
the National Student Clearinghouse, we've been serving the education and workforce communities as a nonprofit organization for 33 years this month, actually. Our mission statement is to serve the education and workforce communities and all learners with access to trusted data, related services, and insights. So we're a data services nonprofit company serving the education community and also employers as well, which I'll get into. We were started in 1993 to solve a very particular problem in the student loan industry. At that time, you may know, probably do, that in the federal student loan programs, a borrower does not have to begin repaying their loans until they're out of school. So if they're in school, they get what's called an in-school deferment. Well, back 33 years ago, in the guaranteed student loan days, there were hundreds of lenders in the federal student loan programs and thousands of institutions of higher education. And it was very cumbersome for all those thousands of institutions to report their enrollment to hundreds of lenders, and cumbersome for the lenders to receive that data from thousands of institutions. So they created what was then called the National Student Loan Clearinghouse. We changed our name a few years later. But they created the clearinghouse to solve that problem. And we still do this today, even though new student loans for the last 16 or so years have been originated by the U.S. Department of Education as direct loans. But we still receive enrollment data on a regular cadence from institutions.
Can I just interrupt to ask a question? That's the average length a student loan takes to repay? 16, you just mentioned that. So just curious.
Yeah, I don't actually know the answer to that. It's over 10 years, I know. I mean, the standard, used to be 10 years. I don't actually know what the standard is, but the service we provide is we receive that enrollment data from institutions and then report it to the Department of Education. And we still have some legacy federal student loan, and we serve also private student lenders as well, I should say. The Vermont Student Assistance Corporation is a partner of ours, an entity that we serve in this way. So I could certainly find out that information for you if you'd like. Yeah.
Just be interesting. Sorry, keep going. You said 16 years, and I thought, really? Is it only 16 years?
Yeah, it's. I think it was the legislation in 2010, I believe, or 2009 or 2010, where it was move to 100% direct lending. But there's still legacy, there are still legacy guaranteed student loans out there. So we still do serve that, and private loans as well. But since then, we've expanded to many other services. So we do degree verifications is a big one. So that, for example, if Jane Doe, who's a graduate of the University of Vermont, is applying for a job and that employer wants to just verify that Jane Doe actually does have a degree from the University of Vermont. So University of Vermont doesn't have to respond every time an employer asks that question. They send us their degree data and we respond on their behalf. That's free to the institution. We do charge the requester. So I should say, just to give you an idea of the scope of our enterprise, if you summed up all the degree granting Title IV institutions in the United States, summed up all their student enrollment, we have over 95% of the enrollment data on those students and over 95% of the degree data on those students. So it's the vast majority of institutions of higher education in the United States use the clearinghouse, including the vast majority in Vermont. We also do enrollment verifications. So if a business, for example, wants to give a discount to a student, but they want to make sure that individual actually is a student, they can use our service to do that. We also have a research collaborative. So about 15 years or so ago, the clearinghouse realized that all this data that we have has research utility. So we publish aggregate reports. They're available on our website. They're cited in the press quite a bit about student enrollment and trends in student enrollment and completion and persistence and those sorts of metrics. We also have a service called Student Tracker, where a high school or community college or any institution that wants to know what was the subsequent educational pathways of their graduates. Did a high school graduate go on to get a bachelor's degree? Did a community college graduate go on to get a bachelor's degree, for example, or even enroll in further education? They can find out that information. We provide that consistent with FERPA. I should say this is all governed by the Family Educational Rights and Privacy Act. We are a school official under FERPA, and that's important for the purposes of H211, which I'll get to in a moment. But we receive this data under FERPA. Education records can only be disclosed with consent of the student, or if an exception applies. And one of the largest exceptions is the school official exception, where the institution can send us data and we perform a service they would otherwise use employees for. But the data has to be under their direct control. The use and maintenance has to be under their direct control. So we charge for the verifications and these student tracker reports. And for that reason, we fall under the definition of a data broker in Vermont. We don't qualify as a data broker in any other state. And I should say our business model is not the buying and selling of consumer data without consumer knowledge or meaningful accountability. And we're not a for-profit entity. We're a 501c3 nonprofit. We're mission-driven. And we're a service provider to the education and workforce communities. And our use of data in these services is very transparent. You can find out about what our services are and how we use data in those services on our website. So we're very upfront about it. For these reasons, we believe the clearinghouse should be exempt from the definition of data broker in Vermont. However, we realize that that's not something that's on the table at this time. What we're asking for is a more modest request, and we've been working with Representative Priestley and Legislative Counsel Rick Sagel on developing an exemption. I think we've landed on some mutually agreeable language, which of course I'm happy to share with the committee, but I wanted to share these concerns so you'll understand the background.
We appreciate, and we don't yet have Ledge Counsel here. I'm not clear if he's coming or not.
On his calendar invite, I'll check.
Okay, well, we're finding out where he is.
Okay.
As we funnel towards the end of session, our modest legislative council staff, as you all know, we have no personal staff here, and we share
Right.
legislative council staff and joint fiscal staff, and they're spread very thin at this time of year. So
Yeah.
he will have language. Have you worked with him on language?
Yes, yes.
Okay, so
We have. And if I could just discuss the two reasons for the language, it's essentially expanding the data processor exemption so when a consumer requests deletion, there are some exemptions in the law for that data brokers can retain the data. And the reason for us sort of expanding on that exemption is we don't want there to be a conflict with FERPA. Because as I mentioned, FERPA, the school official exception under FERPA requires that the institutional data provider still be under, that the data be under their direct control, the use and maintenance of their data be under direct control, their direct control. And if a consumer can come along, regardless of the institution's wishes, and require us to delete their data, then the question is, is that institution still in control of that use and maintenance of that data? The second reason is it would negatively impact the institutions and students we serve if, a student, an individual comes along, they don't really take the time to understand what the clearinghouse is about. They just say, "Oh, data brokers, I want to delete all the data my data and all the data that's held by all data brokers." And then we don't have their data when it comes time for them to get a loan deferment or a degree verification. Those services would be disrupted, delayed, or even denied, perhaps, if that data is deleted from the clearinghouse. So those are the reasons we've asked for the exemption, and we've worked with Rick Sagel and Representative Priestley as well, and I think we've landed on some in a good place that's mutually satisfactory. So,
Right, terrific, thank you. He's headed over, and we will look at any new language that's been developed by anybody here in the room at the moment. We'll look at the end of testimony. We'll go through that. Thank you. Any questions? Anything else, Tracy, before we ask questions?
no, I don't think so.
Where are you headquartered?
Yes, we are headquartered in Herndon, Virginia, near in the DC area.
Great, thank you. Randy, you have a question?
I do. Just talking about the business model that you have, you mentioned that if someone wants a degree verification, you provide it for a fee for the institutions. Is that right?
Not for the institutions, for the requester. So it's free. It's free to the institution, but if a background screener that's working on behalf of an employer or an employer themselves, we do charge there. That is part of our revenue.
What do you charge?
It's a modest fee. I would have to go back and look. I want to say it's I should know that, but it's less than $20, I believe, per verification. But
Does the institution refer the person to you?
no. We do it on their behalf. So the screener or the employer comes to us, and we
How would they know to come to you?
Well, I mean, the institution will in the first instance, they will let the big background screeners know to come to us. The employer, they would refer, they may contact the institution, but the institution would refer them to us, and then we would
To you.
Yeah.
Just curious, in terms of institutions in Vermont, do you represent most or many of the colleges in Vermont?
I would say the most, definitely. I could certainly get you the exact list of which institutions, but the majority, I would even venture to say the vast majority, are going to use the clearinghouse for both the enrollment reporting and the degree verifications. And in fact, the Vermont Agency of Education has used our student tracker. I believe they're still active. Our student tracker service I mentioned a lot. One thing I didn't mention is diploma verification. So that's a relatively newer product. It's we've had it for a little over 5 years, I believe now, and some school districts in Vermont will use, and private schools and individual schools will use the clearinghouse for employers to use employers will use will come to the clearinghouse to verify the diplomas, high school diplomas as well for employment purposes.
As workforce, as we re-embrace career and technical education and have more certificates and apprenticeship certificates, are you also recognizing those which are like diplomas but not technically?
Yes, for if they're offered by institutions of higher education, most of those are in our system
Okay, great.
to be verified as well. Yes.
All our workforce is represented.
Yeah, outside of the we have a small program. We're hoping to enlarge it, but we do have a small program for workforce credentials or industry credentials,
Yes.
non-traditional credentials. So we're certainly aware that
that would be great to build, Thomas.
Yes. That is something we've been looking at. And
great. We encourage you to expand that. Thomas, that's a
Tracy, I'm fully supportive of this language. One note I'd add, I currently represent the Vermont State Senate on the New England Board of Higher Education. And I don't know if you're familiar with that organization, but there are about 7 of them that regionally coordinate higher education advocacy and policy aspects. So if you haven't connected with them, it might be useful to do so as other states look at these same laws. Model legislation coming from NEVI can be a very useful thing. So maybe that's already on your radar, but might save you some time down the road and get more of these states to adopt the same type of language that meets your needs for this purpose.
Yeah.
Yes, thank you. I am familiar with NEVI. In an earlier life, I worked for a New England senator, U.S. senator, and actually interacted with NEVI a few times in that capacity. So that's a good suggestion. I appreciate that.
great. Terrific. Thank you very much. Any other questions? Thank you, Tracy. Much appreciated. We'll have Rick in a bit.
Okay, excellent.
I take for Sarah.
I am.
Well,
Have a good day. Bye-bye.
yes, thank you. Stay with us if you want to continue with the conversation. We're happy to have you.
Okay, I'm afraid I have a previous.
You might actually have other things to do. We get that.
Yeah, but I appreciate it.
Thank you so much.
Yeah, thank you. Bye-bye.
Sarah, welcome.
Thank you. Good morning. My name is Sarah O's, and I'm Vice President of Government Relations for the Consumer Data Industry Association. We are the trade association that represent the credit bureaus and background screening companies. And I appreciate the opportunity to speak with you today regarding H211 as it's currently drafted. At the outset, I'd like to address what I believe is a fundamental misconception underlying this bill, and that's that the term data broker has a negative connotation. There are lots of different types of companies and data uses that are captured under Vermont's definition of data broker, and companies that are registered as data brokers in Vermont play critical everyday roles protecting consumers and enabling essential services. And these are not abstract functions. They are things Vermonters rely on every day, often without realizing it. So let me give you a few concrete examples. Fraud prevention and identity verification. Every time a Vermonter opens a bank account, applies for a loan, or sets up insurance policy, the institution must confirm that the person is who they say they are. That process depends on historical identity data that allows institutions to detect when a stolen social security number is being used or a synthetic identity is being created. That information comes from a data broker. Compliance with federal anti-money laundering laws. Banks, credit unions, and money service businesses are required by federal law to screen customers against terrorism and sanction lists. Those screening tools on aggregated and verified data are maintained by registered data brokers. Public safety and consumer protection functions. When a vehicle manufacturer identifies a dangerous defect and needs to locate a vehicle owner, they rely on aggregated data and data brokers to reach the right customer quickly and accurately. So a large part of what data brokers actually do is unglamorous, but essential. They're standardizing addresses, they're correcting errors in names and records, they're matching data across systems. And this is the infrastructure that makes everything else work. It's what allows hospitals to match patients to the correct medical records, credit reports to be accurate and complete, government benefits to reach the right individual. And these are just a few of everyday benefits and protections that data brokers provide to Vermonters. H211's broad deletion framework, would have real immediate consequences for consumers by degrading the accuracy, availability, and functionality of these types of services that they rely on every day. And that's why it's important that this legislation include vital exemptions, like those included in every comprehensive law in the country. Use-based exemptions like those in this bill create gaps and uncertainty and are not the approach that are used in any other state. Comprehensive privacy laws consistently include entity and data level exemptions for the Fair Credit Reporting Act, the Gramm-Leach-Bliley Act, the Driver's Privacy Protection Act, fraud prevention and identity verification uses, public records. And these exemptions exist for a reason, to ensure that data systems already governed by strict federal privacy and use limitations can continue to function as needed. It's also important to note that no state has a data broker deletion right that is specific only to data brokers. California is the only state that has adopted a data broker deletion framework that has centralized the consumer's ability to request deletion. However, the California Delete Act was intentionally designed to operate alongside their comprehensive privacy statute, the CCPA and CPRA. It explicitly preserves underlying definitions, exemptions, and consumer rights within the broader framework. Vermont is not similarly situated. Without a comprehensive privacy law in place, H211 attempts to create a standalone deletion regime without the necessary legal and operation guardrails. A more effective approach would be to establish a comprehensive privacy framework that applies consistently across all entity and data uses, including both directly collected and third-party data. Finally, the requirement that data brokers maintain a $20,000 bond appears punitive and is premised on the assumption of non-compliance. A blanket annual bonding requirement benefits third-party sureties while imposing additional costs on compliant businesses. A more appropriate approach would be to require bonding only in cases where a registered data broker has previously failed to satisfy assessed penalties. Additionally, this bill provides a private right of action, and we would request that it be consistent with the Senate position in S71 that says yes to enforcement under the Consumer Protection Law, but specifically carved out the private right of action. I appreciate the opportunity to share our perspective on 211, and I respectfully encourage the committee to consider addressing consumer privacy protections within a comprehensive legislative framework that provides consistent, well-defined exemptions and clear operational standards. Such an approach would enable consumers to exercise meaningful privacy rights across the full ecosystem of data users, rather than a narrow subset of data aggregators defined in current Vermont law. So for these reasons outlined above, we respectfully ask the committee to oppose the bill. Thank you for your time and happy to answer any questions.
Thank you. Betty, any questions?
Irredeemable. There's no changes to this bill that could get you to support it.
There are definitely changes that could take
Like
place.
exemption to DPPS.
Exemptions that would allow, FCRA, GLBA, those types of things.
Those are things that I definitely support doing. That's what's been part of the conversation. So if those exemptions were in there, you wouldn't necessarily be opposed to them.
It all comes down to
Yeah.
the details, but yes, that would certainly put us in a better light.
And our comprehensive data privacy bill is being worked on and will be done, we hope, by the end of this legislative session. So we're on track to do both. So thank you very much.
Thank you.
Yeah, you have a question.
And just overall, as you look at the landscape of data privacy law, does this
Yes.
whole thing make sense, or is this really something that is a federal responsibility and ultimately will be? And if it is, what will happen to what we can do in the meantime, you think?
We believe comprehensive privacy is a federal issue. Fortunately, states have moved faster than federal regulations have, but
Well,
we do.
perhaps for federal, it just will be so low.
Correct. And either way, but we've always believed it's a federal issue because to have a patchwork of state laws obviously impacts commerce. And so we would prefer to be that way. But we have 21, I believe, comprehensive laws in the books right now, soon to be 23 or 24. And so that's out of the gate. But what's consistent about all the comprehensive privacy laws, that every single one of them have all the exemptions that I've noted, and they're all very similar that have been worked on with consumer advocates to ensure that the language provides both the consumer protections as well as the continuity of operations for the companies that have to abide by
Clark,
them.
what you see about what we're proposing here with this bill and the other Vermont privacy statute that's being directed, do you see any point other than what you've described or talked to us about so far that makes us an outlier, makes it difficult for what we're proposing to be enacted without conflict with other states?
I think their data deletion is in conflict and is an outlier. Your comprehensive privacy law as 71 is more in line with what is happening, and I think is the better approach to take. Data deletion, focusing on a subset. Comprehensive privacy applies to all data sets, all companies that are using data and giving consumers the rights to correct, delete, be aware of what's happening. And it makes a data deletion, a data broker bill sort of obsolete because there's nothing inherent about how you define data broker that wouldn't apply to a data user under comprehensive privacy law.
Right. Thank you very much.
Thank you.
I think we will move to Rick. Rick, welcome.
Thank you so much. I appreciate the chair and members of the committee. Thank you for the time this morning.
Good to have you.
Um,
Welcome. Introduce yourself.
Thank you. Rick Gardner, Global Data Protection Officer for LexisNexis Risk Solutions. We are a duly registered data broker in the state of Vermont and have been.
We appreciate that.
Yes, absolutely. And have been since the inception of the requirement. What we do, our bread and butter is identity verification, fraud prevention, and insurance underwriting. We as part of those services, we fit into the the definition of data broker, which, because of the way it's defined, captures in a number of different types of companies. So the things I'd like to discuss with you today are, just kind of some thoughts on, 211 in particular, but also just serve as a resource. Like, how does this work, operationally, and happy to answer any questions that there may be on that front. And if I may, it's kind of a point of personal privilege. I actually spent the first 10 years of my career in state government in the state of Georgia, so it's good to be back in the state house. So
Yes,
thanks
I
guys for
can
that.
hear that.
A little bit, a little twang in there, yeah. But in terms of some of the specific items I wanted to discuss, or some of the things that have been touched on already, one is, right now today, there are over 20 states that have, comprehensive privacy legislation on the book. In every case, those states include exemptions for these regulated data sets that we've been talking about. So FCRA, GLBA, PPPA, publicly available data. Even the California Elite Act includes exemptions for those particular data sets. The second component is just from a compliance standpoint, right? If this bill were to pass as is, we would still have, say, GLBA compliance obligations. So it's kind of having to do those things, kind of in tandem. And then also, and thirdly, I think this is really the most important, the impact on everyday Vermonters, right? So if someone were to delete their data and it was a complete deletion, removal of FCRA data, GLBA data, et cetera, as a practical matter, the issue that they're going to have is when they go to open up a bank account, they go to get an insurance policy, they're going to have a really hard time doing it. I'm not going to say it's impossible, but it's not going to be a very smooth process because the data is not going to be there in order to effectuate that transaction. The other thing I want to discuss, again, just kind of going to as a practical matter, how does this work from a control standpoint? So speaking for LexisNexis, some of the controls that we have in place, kind of honing in on GLBA data, we require all of our customers who are utilizing GLBA data to certify to a permissible purpose, right? The data is only being used for that purpose. That's also backed up by the contract, right? They will say in the contract, this is the only thing that it can be used for. The services are credentialed, right? So it is an appropriate party and an appropriate individual at that company that's utilizing that data. And lastly, we have an audit function, right? So if they have said, we're using it for X, then on the back end, we're making sure that they're using the data, for that particular permissible purpose in order to ensure that data is used appropriately. We're certainly supportive of, good and comprehensive, thoughtful privacy legislation. But I think, in this case, it's just the devil's in the details around some of those, in particular, federal privacy laws and the exemptions of those. So with that being said, I'm more than happy to address any questions that there may be. Again, how does this work? Kind of from an operational standpoint, happy to be a resource on that front.
So I'm just curious on your verifying permissible purposes. Is that an additional service that you offer, or is that something people subscribe to?
So if someone is using a regulated data set, so for instance, if we're providing a service that utilizes,
And so there are regulated data sets and unregulated data sets.
well, so yeah, just to clarify, when I say regulated data sets, I'm really talking about those federal regulations or state regulations, right? So I'll be more precise. If someone is using a federally regulated data set, which also may have a state analog, right? So such as Vermont, right? The specific laws around GLBA data. We will ensure that that data is certified to a use.
So that
permitted.
comes with the data you provide, is that it's all been screened and is verified.
Right, and that our customer is utilizing that data has told us we are only using this data for a use case specifically allowed under one of these federally regulated laws.
So you already are complying with the use cases.
To the extent that that use case, yes, but also to the extent that the use cases are covered under GLBA. So for instance, this bill has an exclusion for fraud prevention, which we think makes sense and we support, is also consistent with other state privacy laws. GLBA includes a permissible use of fraud prevention, so this is consistent from that standpoint. But there are other uses under GLBA that are not necessarily covered by the bill. So for instance, effectuating a transaction requested by the consumer, compliance with law, usage of the data for, internal risk assessment, things of that nature. So on the one hand, you can look at GLBA data as kind of a use case, if you will, kind of base regime, but it is, you have to use consistently. So you can only use GLBA data for those purposes. You can't use it for a GLBA permissible purpose. And speaking for LexisNexis, any GLBA data that we have will only be used for a GLBA permissible purpose. And we flow that down to our customers as well. And we support that through an audit program to ensure that that's how it's being utilized.
Great, thank you. Any questions? There's a random.
The basic question, you looked at the law, if you were sitting in our seat, would you vote for it?
I would potentially, Senator, I appreciate the question. I would say if it were appropriately amended, then yes, right.
And have you sent your, have you been in dialogue at all with Rick Sagal, our legislative counsel, on suggested language?
If
I'm Chad. I take
Yeah.
Bill and Vicky with Lynn on on behalf of LexisNexis. I think we need direction from one of the members of the committee to speak with Lex counsel. We typically are not.
Right.
Allowed to
Well,
do that
you
without
haven't
your
asked, so I'm just curious.
Yeah, certainly more than happy to do.
Well, I would be interested in knowing that if there are what you consider to be flaws or unacceptable forces to know what they are.
Yeah.
And why.
I think the GLBA piece is an exemption that you, if that was addressed, you'd be willing to, you think that this might move.
So I would say
That's my understanding.
yeah, so the GLBA exemption is one of the critical components. Also a consistent exclusion for publicly available data lawfully obtained under Vermont public records law, right? And that's consistent with definition, again, under other states. For us, to use a Georgiaism, if I may, kind of all boils down to, I think kind of those three things. One is, consistency across the state laws. Two, even within Vermont, we will still have, GLBA data that we will need to comply with. And so kind of alongside, what this law may require. And then thirdly, and most importantly, the impact on everyday Vermonters who fully respect and appreciate and support them having rights over their data. But it's kind of the unintended consequence. If somebody says, hey, delete all my data, they may not know the practical impact of that when they go.
Well, and I think that's one of the reasons we're having the Secretary of State do the work they're doing, and it's not wanting to reinvent the wheel, but looking at California's data deletion portal and seeing how they can work with that. And yes, because there is lots of data for good. We're all clear on that.
Yes.
And I like I love your input though, because we are all indebted to data for good.
Yes.
To enable our lives in many ways.
Absolutely.
And on the other hand, we also know of the harms that have happened as a result of some of that. So, and we also have to be clear on the data that we're asking to delete. I think this is critically important. Public education on this is so important
Absolutely.
because you don't want to delete data that is going to benefit you when you want to buy a house or when you want to buy a car.
Right.
Or when you want to do whatever you want to do that
Right.
requires a verification of who you are and why you need it.
Right.
So,
Exactly.
we're clear on that, but so my clarity is your GLBA exemption
Mhm.
and the exclusion for public obtained data. Is that correct?
Yeah. So again, just to be very specific,
Be very specific. We're at the specific point
Yeah,
in the legend.
absolutely, yes. Yeah, very much appreciate that. So I know we've kind of honed in on the GLBA exemption in particular. But so the GLBA, FCRA, Fair Credit Reporting Act, and then Driver's Privacy Protection Act and publicly available data would, but again, falling under those same three buckets I mentioned, consistency, internal, Vermont compliance with the Vermont
Yeah.
law and the GLBA, and then
Right.
consumer impact.
Thanks. Just so
Yeah.
we're clear.
Yes.
Because we don't
absolutely.
have any time to waste.
I-
Everybody has now been so constrained on its time. that
Yes.
It's going to be a challenge.
Yeah, I truly appreciate that. Yeah.
Right. Any other questions? Anybody? Okay,
Great. Thank you
great.
so much.
Thank you and Karen
Thanks,
both
everyone.
for coming.
Yeah.
We appreciate, and I hope you can stay for the rest of the morning here. We have Ryan and Emery. So Ryan, you wanted to go next. We welcome you back. As you all may remember, Ryan helped us craft our first data broker bill many years ago. Yeah. Oh, you can't see it, but you're getting applause from Emery in the back. Thank you, Emery. We are appreciating it. Brian can't see it, but thanks.
My name is Ryan Krieger. I am a resident of Montpelier, Vermont. I have over 20 years of experience as an attorney and specialize in consumer protection, privacy, and data security. I work for the Vermont Attorney General, the Federal Trade Commission's Division of Privacy and Identity Protection, and I'm currently the Deputy Chief of the Massachusetts Attorney General's Privacy and Responsible Technology Division. I also teach about privacy, consumer protection, public policy, and administrative ethics at the University of Vermont. I testify today in my personal capacity as a citizen of Vermont. That testimony does not reflect the positions of the Massachusetts Attorney General or that of her office. I was just noting on the agenda, I am listed as former FTC Commissioner. I appreciate the.
Oh, no,
notion,
you're not.
but-
Even I know that.
And if anybody wants to make a recommendation, I'm happy to take it, but no.
No, I think your current title in Massachusetts is just great.
Right, okay, so, I'd like to start with some big picture observations about the industry and then try to address some of the specific concerns that have been raised. The data broker industry has been around for decades, but didn't really experience public scrutiny until around 2014. They've had over a decade to address the many concerns that have been raised about them. But it appears that rather than try to reform their industry, they have instead decided to dig in their heels and oppose efforts at reform. There are likely over 1,000 and potentially many more data brokers out there. Some data brokers are very large and sophisticated, like LexisNexis. Others appear to be very small, like National Public Data, a data broker that had a massive data breach of almost 3 billion rows of data in 2024, likely about 100 to 200 million consumers affected. What that shows is there's not necessarily a correlation between the size and sophistication of a data broker and how much data they are able to amass. Okay. Many data brokers don't seem to have any scruples about who they'll sell your data to. Congress had to pass a federal law in 2024 to stop data brokers from selling our data to foreign adversaries. LexisNexis has been sued for selling immigrants' data to ICE. Note, that was in 2024. They were able to get that case dismissed. But in their motions to dismiss, they did not deny that they were selling data to ICE. They merely said they emphasized that despite plaintiffs' claim to a right to privacy, quote, no such right exists. And I would posit that that is kind of the business model of data brokers. No such right exists.
Do you know what data they were selling to?
Actually,
And it was directly to ICE.
they have a contract with, well, it was Homeland Security, and I believe it was also ICE and Security. Yeah, and it was data to help them identify people to report. I can get you a copy of the
Yeah,
that
will be
helpful. So, back in 2006, the Federal Trade Commission actually levied the largest penalty that ever implemented, $10 million, against a company called ChoicePoint for selling people's social security numbers, birth dates, and credit histories directly to identity thieves, causing the actual compromise of over 163,000 consumers' financial data. ChoicePoint was then required for about 4.1 billion actually by LexisNexis. But even if the data brokers are not affirmatively trying to sell your data to foreign nationals or to identity thieves or anything like that, the very fact of their having the data puts us at risk. And that is because data breaches exist. It is impossible to guarantee that any company can keep our data safe. The Equifax data breach in 2017, that turned out to be China. And if China wants to get your data, they're going to get, if Russia, North Korea want to get your data, they're going to get your data. This is one of the reasons why we've seen in all the privacy laws, and thankfully in the comprehensive one we're looking at, this notion of data minimization.
Right.
A data minimization requirement, if there is a silver bullet in the privacy and data security world, it's data minimization. The idea being, don't collect more data than you need. Okay? Sure, you're probably going to get breached. But if when you get breached, you've deleted old data and you haven't collected too much data, at least you'll minimize the harm to consumers. And what's also great about data minimization is it doesn't require consumers to opt in or opt out. It just says to the business, don't collect more data than you need. The obligation is on the business, not the consumer. So data minimization, and by the way, that's also a best practice within the industry. Before laws started implementing it, a lot of businesses were already going to minimization. Here's the thing, the data minimization doesn't make any sense for the data broker industry. The data broker industry's business model is data maximization. They want to collect as much data as possible. So any section that says don't collect more data than you need, as it applies to brokers, it's a disconnect. So if data brokers are going to be committed to collecting as much data as they possibly can about us, then the only way we can protect ourselves is by saying, look, I'd like you personally to delete my data. Okay, unless you absolutely need it for, say, Fair Credit Reporting Act, which, by the way, this law has an exemption that says any data used for Fair Credit Reporting Act is exempted. If someone goes to a data broker and says, please delete this data, they can deny it under this law. So I'm not sure what the objection on Fair Credit Reporting Act is, so I'm even okay. I heard, by the way, last week, a representative of the insurance industry came in and said that they were concerned that they would have to delete data, older data, which related to investigations under this law. I didn't understand that because insurance companies are not data brokers. This is something that's really important to understand. This law only applies to data brokers. So banks are covered by Gramm-Leach-Bliley. They're not covered by this law. So exempting Gramm-Leach-Bliley isn't going to do anything specifically to banks. They're already outside the law. Okay. It might limit some of the data that they have access to. Not Fair Credit Reporting Act data. If it's data being used to implement loans or anything like that, they still have full access to that data. The thing that you have to remember is that anytime a company comes in and says, well, I have this very specific use case that I need this data for, or I might need this data in the future for some amorphous use case I can't define, they're saying, and that means you need to let thousands of opaque, some very shady companies have as much of your data as you want to, expose it to theft by fraudsters, by foreign governments, by whatever, because the two are coupled. Either everybody gets to have our data and do whatever they want with it, basically, with certain exemptions, in order for them to have those carve-outs. Now, my understanding is that there is discussion about certain carve-outs, making amendments. I think that's great. I trust Senator Clarkson. I trust her counterparts in the House Committee to be having those conversations and making those discussions. All I ask on that is that if we're talking about exemptions, try to keep them within Section 2446C3, which is where the exemptions are. If you see an attempt to say amend the definition of consumer or amend the definition of data broker, that's just the backdoor way of trying to kind of gut the bill with language. Okay. we don't have a lot of legal rights to privacy because every time a state tries to get a legal right to privacy implemented, the industry shows up and is able to convince the committee why they need to just tweak the language here or tweak the language there in order to give them kind of loopholes they can drive a truck through. I'm very comforted by the level of sophistication of the committees in Vermont that have been working on this, which is why I feel, very trusting that you guys are gonna be able to get the language right. I know that, especially on the House side, so much consultations happen with data science, industry members, and computer science professors. There's just been a lot of thought that has gone into this. Could additional exemption be carved out? Sure, and I'm sure that conversation is happening, and I think that conversation should happen. So I did want to just kind of mention that. If there's any other thing I want to. I also just want to say that well, I don't know, over that point. Those were kind of like key things that I wanted to know. Oh, in terms of the Grand Ridge Wiley Act and broad exemptions, I did want to note that the Consumer Financial Protection Bureau will be providing this report in November 2024, actually issued a report about state privacy laws exempting GLBA, and they said, don't. Now, this is CFPB, they're the ones who enforce GLBA. They basically said, it's a good law, but it has a lot of lacking protections, and if states give this kind of big, broad carve-out, they're actually not going to be protecting people as much as possible. Now, they were talking about comprehensive laws in that case, but I encourage folks to look at that law.
Can you email that
Oh,
to
yeah.
us, and
Yeah.
so that we can have a chance?
Absolutely. I'm also going to be including this report that just came out this February from the Joint Economic Committee about practices of registered data brokers and the multi-billion-dollar cost of breaches that they can have. Because again, just the fact that they have so much of our data exposes it to all of these potential breaches. And none of them will sit here and say we can guarantee that we'll keep it safe, because everyone knows at this point that that's just any false statement. And again, Federal Office of Personnel Management has been breached. The NSA has been breached. This isn't saying companies are being negligent. It's just saying these guys are really good.
Yeah.
Right. So it just can't be protected.
And then cleaning, I mean, what we found in 2017 is that the cleaning up, the closing the door after it's been open is just very challenging for people.
Oh, absolutely. Once your
We had
data
this, it was very,
yes, once your data's out there, fixing the identity theft is very, very difficult. And by the way, just as a side note, one kind of defeatist attitude I sometimes hear people say is, well, our data is already out there, so why are we even bothering with this? And the response to that is, one, data ages, data becomes much less valuable over time. Social Security biometrics don't age, but a lot of other data does. So tightening down privacy rights does have an immediate effect. And second, maybe even if all of our data is already out there, our kids' data isn't. Their grandkids' data isn't. They're like, maybe we've messed up for our generation because the technology came on too fast, but we can still make a change. We can still fix things for future generations. And I think that is a laudable thing to do. The last thing I want to talk about is enforcement of the law. Okay. I was just reading an audit report called the California Audit Report, and I will share that link with the committee, by an organization that looked at the California privacy law, specifically their global opt-out signal and compliance with the law. And what they discovered, unsurprisingly, is rampant non-compliance with California's law by major corporations, by small corporations, just across the board. And the reason that that's happening for the major corporations, Google, Meta, is because pretty much any penalty they pay is not going to be more than what they probably profit from violating the law. But the fact of the matter, and I've been doing this enforcement for a very, very long time, if you violate one of these laws, first you have to be caught. Then it has to be reported to an AG's office, and the AG's office has to decide to look into that particular violation as opposed to the 100 other violations they know about. And then if they do investigate that violation, and that could take a couple of years, they have to decide, go forward with it. Like there's so many points at which enforcement can fall away that it's often kind of worth rolling the dice and just saying, well, we're going to go for it. That's why enforcement mechanisms are so critically important. If we're going to pass a law that isn't really going to be enforced very strongly, and by the way, I know the AG is going to do everything right. I'm not doubting that at all. But, they have, I think, 7 attorneys in the public protection division, and maybe one of them will be able to be freed up to enforce this law. They can only do so much. And that's why I do want to talk briefly about private right of action. Okay. Now, industry has done an amazing job over the past couple of decades of demonizing the private right of action. And so I want to be very clear here. Even the term private right of action, PRA, it kind of abstracts this concept. Okay? Imagine we live in a world where you're driving down the street and someone hits you with their car and you get into a fender bender. And you say, well, I need you to pay for the damages. And they say, well, we're not going to do it. And you say, well, we're going to sue you. And they say, well, you can't because there's no private right of action under negligent vehicular. You have to just go to the attorney general and ask them to enforce for you. You can't enforce your own rights against me. That's what a lack of a private right of action. All a private right of action says is if someone violates the law, as to me, I get to do something about it. What's the remedy? First I go to them and say, could you make it right? And if they don't want to make it right, then I go to the courts and I say, look, they're not going to make it right. If we lived in that world where there was no private right of action for, vehicular damage, and we tried to put one in place, I'm sure we would hear from the auto insurance industry saying, don't give them a private right of action. You'll get all sorts of lawsuits from it. Well, of course you will, because that's how you enforce the private right of action. You have to have lawsuits, right? So, the Fair Credit Reporting Act has a private right of action. That was passed in 1970. Laws used to generally have private right of actions before kind of industry started really getting really good at showing up in places like this and convincing people why it's
So that's a federal right.
That's a federal right.
And we have a PRA in our consumer protection.
I believe we do. Yes.
Yes, we do.
Yes.
So how does that, I think this is a question many of us have, how does that not exist for all of us in all areas in Vermont? If we have already embedded in our statutes private right of action in consumer protection, how is, and maybe this is a question for Todd, but how is that not protecting us now and enabling us to already sue if we have a problem?
We can. People bring private suits under consumer protection law. You buy a car that they lied to you about, you can sue under Consumer Protection Act.
Conceivably, with the PRA already existing in our state statutes, could it not already be used in these cases?
I believe under the current language, yes. Now, what other laws tend to do is they say there'll be a clause in it that says nothing in this law indicates private right of action, or only the attorney general can enforce this. So what they're doing is they're taking that private right of action because they say enforced as per, 9 VSA 2453, but not with regard to this law. For this law, only the AG. But for this law, there's no private right of action. That's the language that shows up in other laws to get rid of it. And this law, to my knowledge, does not have that. And again, we've had private rights of action in Vermont for a long time. You don't see massive class actions happening. Companies are not getting bankrupted due to frivolous litigation. I mean,
Todd has testified to that.
Yeah,
Yeah.
We have in Illinois, right? So I've encouraged everyone on this committee to read and understand what's happened in Illinois over the last 10 years. And their Supreme Court, which was hearing maybe it's somewhere between 10 and 20 lawsuits about their data privacy bill, called their, I don't think it's been amended, honestly. They were going to try and take out class action lawsuits, but the Supreme Court said that the data privacy bill in Illinois had annihilative power over certain entities. And the majority of those sued in Illinois were hospitals. That was the case that was being heard when they were talking about annihilative power. Hospitals, senior centers, school districts. They do have some high profile cases with millions of dollars extracted from big tech, but most of the cases there have been against smaller entities that are within the reach of somebody to sue. Do you have any response to what's happened in Illinois? Because I don't want to be Illinois.
Absolutely. So you're referring to the Biometric Information Privacy Act, BIPA, in Illinois, which is probably one of the only laws, if the only privacy law out there that has terminology like this.
And as a private right of action.
Well, let's be clear. Yes, they have a private right of action. They have a private right of action coupled with liquidated damages. Liquidated damages means in the statute, it says a violation of this law will cost you $1,000 per or $5,000 if it's intentional. That's why it is such a strong and difficult law, because it has this huge penalty attached. Now, the Consumer Protection Act says the Attorney General can seek up to $10,000 per violation. Private actors do not get that. Private actors can get damages. Okay. And if they can prove really bad actions, they can potentially get treble damages or possibly treble consideration, which is generally nowhere near $1,000 or $5,000 or anything like that. Okay. And having to prove damages in a privacy case is incredibly difficult to do, which is why I think you're not going to see a landslide of private rights action. There is no liquidated damages. By the way, Vermont's Fair Credit Reporting Act, our state version, and the federal one actually do have liquidated damages. In Vermont, I think it's like $100 per violation or something like that. There have been some
Probably
cases.
hasn't been updated for a while.
Yeah, the point is that even liquidated damages clauses exist in Vermont, and they have not been ruinous. Okay. In Illinois, they have had that 1,000, 5,000. And by the way, what I find hilarious about BIPA is BIPA basically said it has two requirements. You have to have a retention schedule that you declare to people. And if you collect someone's biometric information, you have to get permission first. That's the entire law. The fact that so many companies have trouble complying with ask permission to get biometrics and share your retention schedule, it's like I'm kind of stymied by how that is. A lot of these cases, by the way, happen while tech companies had the cases tied up at the federal level. For a long time, federal courts had put a block on the law. Okay, because under federal courts, they have different requirements. And so I think a lot of this action, a lot of companies are saying, well, we don't have to comply with this law because the federal courts have blocked it. And then there was a case that went up through the state court, I want to say Six Flags, in which the state Supreme Court said, no, this law is actually fine, and it went forward. So I think what happened was a lot of companies that were just ignoring the law suddenly found out that the law actually was in effect, and suddenly they were on the hook for damages when they thought they could just ignore it. Because this is the point. If the state passes a law and there's no decent enforcement mechanism, a lot of companies, not all companies, but a lot of companies would just ignore the law.
Thomas.
I'm trying to reconcile your example or corollary with a vehicle accident with what I just heard you say, which is that it's very difficult to liquidate and identify damages in a data breach. But in a vehicle accident, it's pretty darn clear what the damage is and which parties are involved. And that's partly why a PRA is problematic, and that it is so difficult to identify what the true actual damages are and could get a lot of nuisance lawsuits. How would you reconcile those 2 points?
So good point. So yes, you're absolutely right. In auto damage, I mean, we have whole science on figuring out what the damage is. If you have a violation, first off, so for damages in here, I suppose the damage would be you ask someone to delete your data, they didn't delete your data, right? That would be what you would be suing over. So they didn't delete your data. How is that damaging you? Frankly, I'd be surprised they can convince a court to get damages just for not deleting your data. But if they didn't delete your data, and then they had a data breach, and then you can show identity theft arising from that data breach. Okay, how much damage were you damaged from the identity theft? But you see, a lot of steps have to happen for that to happen, including connecting this particular data breach to the identity theft you experienced, which sometimes is possible to do, It has happened in the past, but it's rare. So in other words, in a circumstance where some data broker didn't delete my data, and as a direct result of that, I suffered identity theft, I may go to the AG and say, please do something about that. But with a private right action, I could go directly to that data broker and say, the $10,000 of damages, the $100,000 of damages I experienced was because you didn't delete my data. You should make me whole, just like in almost every other, realm. So that's I think why it's important, and why I really don't think, because we don't have liquidated damages, and because plaintiff lawyers are smart.
Liquidated damages to go to Illinois. So what Keisha's asking is that then that the Illinois case doesn't really apply to our PRAs here
Because we do not have.
because we don't have
set
liquidated
amounts.
damages.
Correct. Under the Vermont law, it's damages, or what they say called treble consideration for exemplary damages, which would be really bad, it's cumulative. I'm not even sure what treble consideration would look like to a data broker, because consideration is how much you paid them, and no one pays a data broker directly. So I'm not even sure how that would.
Well, I mean, my larger point was that a lot of entities that simply do need people's data for ID badges and keeping, pharmaceuticals safe, et cetera, are the ones that get caught up in these lawsuits. It's not always Facebook. It's smaller entities that might rely on a data broker. And then, because we heard you say, well, they shouldn't be doing that either, but I just think having a lot of power to sue nonprofits and public entities like our hospitals and schools is also of concern, and it was been of concern in every data privacy bill we've had.
So, and
Utilities.
to be clear, we're talking about this bill. Hospitals are not data brokers. Nonprofits are not data brokers. I won't say nonprofit data brokers. So none of them can be sued under this bill because they're not data brokers. This bill only puts obligations on data brokers.
I know. I'm just talking about the larger data privacy conversations that we've have brought in a lot of entities that, we were down to, like, if you keep track of 6,000 or more people's data, I think in the last bill, and the one that we might see, we might see some return to some threshold, given that we have a data privacy bill out there. So I just want us to be clear that it's not just big tech that gets sued with these bills. It can be a lot of local entities.
It is correct, but again, the reason we see so many in Illinois is because of that $1,000 per. Because what $1,000 per basically is, you may or may not get that from a court, but it gives you huge settlement leverage, right? Nobody wants to risk that a court might, give them that massive penalty, but we don't have that settlement leverage in Vermont because we don't have liquidated damages. So
we do have, I don't know if the Attorney General's office is in here. We do have businesses that are sharing with me, large requests for money for some consumer protection issues that have been raised. $500,000, give us this now so we don't take you to court. That's really happening right now. And I we do have to really pay attention to, most of that data is coming from consumer protection complaints, through a kind of voluntary student learning program.
what are you talking about? SOPIPA? Is that the
I'm talking about Consumer Protection Act complaints.
right? You said student learning system. That's the ed tech bill, I would assume, that is also enforced.
No, I'm talking about how the consumer assistance program in the state, in the Attorney General's office, is run through UVM. So that's where the data originates.
Oh, I see. Look, it's impossible to speak to a specific incident. $500,000 to a company that's, hurt people for $500,000. I don't have a problem with that. I'd like to know, we have companies here that are multi-billion dollar companies. I have no idea what that case is about. Okay. It's also very well known that initial demands are always much higher than what anyone thinks they can settle for. That's if it's a settlement negotiation. So, defamation cases notoriously start with, you owe me $2 billion, and then eventually it's much lower. You can't look at the initial complaint or the initial demand. But again, we don't have that liquidated damages here. I really don't think we need to worry about That's why you see so many in Chicago, because plaintiffs firms see that liquidated damages and say, oh, we can bring these cases and we can get some pretty good settlements. But they can. If they didn't want that, all they have to do is comply with the law, which is not that difficult to comply with. Which is why I really do think we need to give people the right to enforce their own rights under the law. I mean, it's just such a common sense situation, which has been, again, the law for, up until, a couple of decades ago when, the tide turned and suddenly it became much harder to enforce against companies. And we've kind of seen what's happening with that with big tech and these other companies is they basically have been allowed to run away and do whatever the heck they want.
Okay, just curious, because I'm not a lawyer, maybe married to one, maybe produced one, but and so the difference, and I think some people will be thinking, oh, class action suits, how do class action suits fit in with this?
Sure.
So how do class action suits fit in with the private right to do things as versus a collective right, and who creates it as a class action suit as opposed to an individual suit?
So
is that a question that belongs here or not?
sure,
Or is it partisan? Because I know we have to move to Emory, so I just
Sure.
think that some things could still exist as a class action suit, I assume.
Sure. So class actions are actually, again, another demonized term. They're not a bad thing. What a class action says is that if a company has damaged 1,000 people, instead of 1,000 individual lawsuits going against that company, they can join as a class.
And
That's efficient for everybody.
That's what our AG's office is doing on behalf of us in
Well,
many cases.
Well, we don't, no, the AG does not do class action.
Oh, so
Okay, sometimes defense counsel think they are, but
Right.
no. The AG does not do class action. The AG sues on behalf of the people, just
Okay.
on behalf of consumers.
oh, that's a big class action.
Well, except that there's actually like a specific procedural rule that covers class action, and you have to certify the class. There's all sorts of hurdles you have to jump to get a class action certified. None of that applies to the attorney
Right.
general. They just sue.
And it doesn't apply to anything in this bill either.
Correct, to my knowledge.
Right.
No, I mean, if there is a company that, again, doesn't delete 1,000 Vermonters' data and 1,000 Vermonters suffered, identity theft as that string that happens, and they want to bring a class action under this, I think they probably would be able to. But again, that was a data broker that should have deleted people's data when they asked them to.
Right.
And why didn't they? Again, it's like, and they'll say, oh, frivolous suits, shakedown suits, all this other stuff. Procedural law has Rule 11. They have protections for these sorts of things. I'm not going to say they never happen. I'm not going to say that lawyers don't, there aren't unscrupulous lawyers out there. Of course there are. But to say, because some unscrupulous lawyers are going to do unscrupulous things, we need to remove the right of all Vermont citizens to seek relief if they're harmed, seems like overkill in the other direction. That's what I'm saying.
Thank you. Anything else that you'd like to add?
I'm sure there is.
And
but
your
that's-
testimony you'll send to us, yes.
Yes. Yeah, I mentioned that, amendments, I think the definition of data broker and consumer is perfectly fine, and I leave that alone. And I think that, if there is a need to put additional exemptions for use case exemptions, I believe those conversations are happening and they make sense, but I think that keeping out the kind of broad law-based, broad database, industry has done a really good job of stopping that from happening in other states. The easiest way to stop something from happening is saying, well, it's never been done in other states. That's why it's like.
With that church,
So-
or the other states, though, right?
Exactly. But the reason they're fighting so hard in this state is not because they're worried about additional liability in Vermont or teeny tiny. The reason they don't want it in this state is because if we get it in this state, just like we got the data broker registry in the state, other states might go, oh, it is possible to do that. Oh, that is actually a good idea. Let's replicate their language because Vermont actually had the guts to stand up to these guys and actually put good policy in a place where it's a lot harder to manipulate our legislators because it's a small state. They're all very responsive to our constituencies and things like that. So that could mean New York, California, Texas is more likely to get something like that. That's what they're afraid of.
But our job is still to help Vermont.
Absolutely.
That is our primary job.
Right.
That's Alexa.
Yes.
Great, thank you. I think David.
So I recognize that Andrew's up next,
Yeah.
but I'm curious if we're going to have time to do a little counterpoint, for a couple minutes. We're not going to have another opportunity, I believe, to have
With all
different views in the
different
same
views in
room.
the same room. It's exactly. So why don't we have Emery go and then let's see if we have that. Let's make time for that.
And I'll just say, I would like to hear more about sale of data to the federal government. I think that's what most Vermonters are concerned about right now. I'm frankly not
Right.
as concerned about Resi and King Arthur Flower. It's like things like that.
Thank you, Ryan. Really appreciate. And Emery, let's turn to you and then let's make time for that back and forth if we can.
Sure, I will.
That's
I
so
will
many-
do my best to be brief. And I probably looked like some sort of oversized bobblehead, just nodding my head to most of everything that Ryan was just saying. So I think that there's going to be a lot of overlap here. I'll just dive right in. Chair and members of the Senate Committee on Economic Development, Housing, and General Affairs, thank you for the opportunity to testify today. My name is Emery Roan. I am the Associate Director of Privacy Rights Clearinghouse. We are a San Diego-based consumer privacy advocacy and education nonprofit, and we're also proud to have been a sponsor of the California Delete Act. We also manage a database that tracks data breaches reported in the United States, with nearly 100,000 data breach notifications analyzed going back to 2005. I testified earlier before the House Committee on Commerce and Economic Development earlier this session in support of H211, and I am grateful to be back to reiterate and strengthen that support. I want to thank this committee and Vermont more broadly, and frankly, given the opportunity, Ryan personally, for leading the charge on data broker regulation. In 2017, with HB 764, Vermont created the first data broker registry in the country, in the world. California shamelessly and gleefully borrowed that framework the following year. What we've been building in California ever since, including the California's Delete Act and the Delete Request and Opt-out Platform, or DROP, rests on the foundation Vermont laid. Vermont was first, and Vermont is once again well positioned to take back that lead. Now, data brokers are by design opaque. Most people have never heard of them, yet data brokers are everywhere, quietly collecting, inferring, and selling information about nearly every American. In 2023, the Markup published an investigation into a single micro-advertising platform.
Oops, just frozen.
Can you hear?
Yes, we
Can
can.
you hear me? I'm going to go.
You're breaking up.
Of course, right at the moment of
Right?
importance.
It's like, well, Rick's sitting right underneath you. What can we say?
I
Tom,
will switch
You
to
want to go
a
out,
different.
come back in?
Yeah, I'll switch to a different microphone really quickly. One moment here.
Okay, we also lost your visual.
Yep. Can you hear me now? Is this
Yeah.
any better?
Yes, we can now see you again.
I apologize for that. In 2023, the Markup published an investigation into a single Microsoft advertising platform. They documented 650,000 distinct audience segments that advertisers could target. These include categories like heavy purchasers of pregnancy test kits, depression prone, and tight money. And that is just one advertising platform. The broader data broker ecosystem is far larger. Data brokers enable stalking and harassment by putting home addresses and daily patterns on the open market. People search sites in particular have been weaponized by domestic abusers to track down survivors who went to considerable lengths to disappear. Last year, let's not forget that the man who assassinated Minnesota Representative Melissa Hortman and her husband and wounded a state senator and his wife was found with a notebook listing 11 different data brokers he had used to try to locate the victims' home addresses. Data brokers also enable identity theft. Ryan brought up the Congressional Joint Economic Committee report last year that found that breaches at just 4 major data brokers cost American consumers more than $20 billion. They enable fraud schemes that target the elderly and people with dementia. And in a country where reproductive care is increasingly criminalized, where immigration enforcement is aggressive and increasingly data-driven, and where LGBTQIA people face escalating political hostility, brokers continue to traffic in reproductive health data, immigration status, gender identity and expression, and information about minors. Duke University researchers have shown that data brokers openly sell sensitive information about U.S. military personnel, including information about their children, for as little as 12 cents per record with little to no vetting of who is buying. And while PRC does not typically weigh in on government surveillance, the data broker market has become a workaround for constitutional protections. Law enforcement at all levels routinely buy data broker data to obtain information that would otherwise require a warrant. And when given the opportunity to step out of all of this, consumers overwhelmingly take it. When Apple introduced app tracking transparency in 2021, giving users a single toggle to opt out of cross-app tracking, 96% of US iPhone users opted out. When California launched Drop on January 1 of this year, more than 240,000 Californians signed up in the first 8 weeks, with 18,000 in the first 48 hours alone. The agency has said that participation has far exceeded its expectations. The demand is clearly there. The feasibility, in our opinion, is no longer an open question. What is missing is the practical ability for consumers in the rest of the country to exercise that right. Now, our own research and the growing body of civil society research into looking at data broker state registries increasingly demonstrates that registration alone is not enough to protect consumers from data brokers. The brokers that should be registered often are not, and the brokers that do register are not reliably telling the truth about what they do. Last year, we partnered with the Electronic Frontier Foundation and students at the Harvard Cyber Law Clinic to pull the data broker registries from California, Vermont, Texas, and Oregon, and we consolidated them into a single data set so that one could cross-reference brokers across the different jurisdictions. The underlying premise was that though there are some differences in scope and definitions, largely, if a broker is required to register in one state and has acknowledged that they are obligated to register in one state, they very likely face registration obligations in others. What we found, however, is that in every single registry we examined, hundreds of brokers were registered in one state but absent from others. For Vermont specifically, last year, we identified 750 unique broker entities across the 4 registries. Of those 750, 309 309 were not registered in Vermont, while they were registered in other states. 199 disclosed collecting geolocation data in other jurisdictions, and 179 disclosed collecting minors data. And the issue has gotten a little more complicated this year. In March, the California Privacy Protection Agency published its new enhanced data broker registry, showing now 795 registered brokers in California alone. Our good friends over at the Electronic Privacy Information Center, or EPIC, recently analyzed that data and identified 33 brokers that self-reported selling or sharing data with foreign actors, including North Korea, China, Russia, and Iran. After EPIC published their research, 7 of those 33 brokers contacted EPIC to claim that the information they themselves had filed with the state was wrong and that they do not, in fact, sell to foreign actors. So putting those findings together, you have hundreds of brokers that should be registered in Vermont that are simply not. And of the ones that do register, a meaningful share are filing inaccurate disclosures. And we only know about those inaccuracies because civil society pulled the registry and some brokers pushed back on what they found. A consumer trying to exercise a deletion right against a registry that is both incomplete and unreliable has been set up to fail. In our opinion, the single most important question in front of this committee today is the centralized deletion mechanism that is now absent from this bill. The House stripped the mandatory mechanism from H211 and replaced it with a feasibility study, and I urge the Senate to revisit that decision. H211 creates an individual right for Vermonters to request deletion from each data broker with a 30-day compliance window, a conspicuous web page requirement, a prohibition on dark patterns, and a confirmation to the consumer when deletion is complete. That right is necessary. It is unsurprising, but kind of disappointing that CDIA characterizes this common sense limited right as a broad deletion framework, but on its own, it will absolutely not be enough. Transparency is essential. But our research demonstrates that alone, transparency does not solve the consumer problem. There are now 795 registered brokers in California, and that is only the ones that register. Asking a consumer to individually identify, authenticate with, submit deletion requests to hundreds of separate companies puts an overwhelming bureaucratic barrier between the consumer and the rights the law supposedly gives them. The evidence on how well this manual deletion process works is also damning. Consumer Reports tested 13 commercial data removal services over 4 months, and they found that only 35% of data instances were successfully removed. The researchers estimated that manual opt-out by individual consumers takes, and I quote, the better part of a work week per broker. A separate study by the firm Yorba looked at nearly 22,000 formal data deletion requests submitted last year and found that only 48% resulted in verified deletion. And this was even with proper submission and documentation. And earlier this year, DuckDuckGo, which also runs an authorized agent deletion service, wrote to the CPPA about what it encounters in practice, including broker websites going offline, opt-out forms changing to purposefully hinder automation, email domains blocked outright, requests with no response after multiple follow-ups, and data reappearing after confirmed deletion. The effect DuckDuckGo wrote was to shift the burden of enforcement onto consumers and their agents. So this is what consumers are navigating. Initiate a request, wait weeks, get told the broker can't find any matching data or that they're not obligated to, or get a confirmation that the data is deleted and then watch it reappear shortly afterwards because it's been recollected, or pay for a service that promises to do this for them only to hit the same walls. Endless back and forth communications, additional verification rounds, and mixed at best results. Now, the Delete Act was designed to flip that burden. The Drop platform creates a single point of entry where a consumer can make one request that then reaches the entire registry, and it obligates brokers to regularly check for and act on those requests. Drop is live today. Data broker obligations begin in August, and 240,000 Californians have already signed up. H211, as introduced, mandated a central accessible deletion mechanism modeled very much on the California Delete Act model. The House replaced it with a feasibility study. And I respect the caution behind the study, but the feasibility question was answered by California on January 1. We don't object to studying how to implement a centralized mechanism, but we do object to studying whether to implement one. The committee should seriously consider restoring the mandatory mechanism or, at minimum, strengthening the study mandate with concrete implementation milestones so that it doesn't become an indefinite delay. 73% of Americans feel they have very little or no control over data the companies collect about them. A centralized deletion platform, a centralized deletion mechanism is what actually changes that. More than registration alone, more even than a comprehensive consumer privacy law. It is what puts the choice about an individual's personal information back in that individual's hands. The centralized deletion mechanism, in our opinion, should not be abandoned. It should be the goal. Privacy Rights Clearinghouse strongly supports H211 and urges the committee to advance it. But we urge it to either restore the mandatory deletion mechanism or strengthen the feasibility study. So the question it answers is how to build a centralized mechanism and not whether to. Thank you again for your time. I'm happy to answer any questions about our methodology or what we learned through the implementation of the Delete Act and Drop in California, or to respond to some of the points that some of our other panelists have raised.
Thank you, Emery. We appreciate it. We will be hearing from the Secretary of State who's been given that study next week. And we, even if we wanted to, we don't have the money to implement that this year. As we know, it cost California a bomb to create that portal. And I think we need to figure out how we also navigate that piece as much as the policy piece, sadly. So it's not a
understood
reality for this year in our budget. Sorry, what?
We would encourage, speaking for the agency, or not speaking for the agency, but having asked this question directly to the agency, they have said that they are interested in working with other state agencies to assist with creating these kinds of platforms. So there's arguably not the need to reinvent the wheel.
Right. We don't need to reinvent the wheel. California's done a good job. We just need to figure out how to Vermont-size it and make it work for us. Thank you. Appreciate it. Any questions for Emery? David, I think you have a question that might engage the incredible minds on this subject that we have in this room.
I do.
Well, you implied that you were.
No. What I'd like to hear is, and we heard some rather stimulating point and counterpoint, but I think it could be appropriate to respond to some of the issues in a short time frame.
Well, we could start with something that's in front of us that we've been asked to consider, which is the GLBA, the exemption from that. So Ryan doesn't feel that it gets us very much, and Rick does. So, I mean, it would be interesting to is that the kind of thing you're talking about?
Yes, ma'am.
So and Emery has a thought.
I would just like to throw that I again was, bobblehead nodding my head to what Ryan was saying earlier. I think that the CFPB report on the limitations of the GLBA and the growing prevalence in state laws is something to follow. I'd like to sort of maybe pointedly respond a little bit to some of the points that were raised earlier about how every state, two things really, but how every state consumer privacy law has this exemption for the GLBA and the FCRA.
Just 20. Just 20.
Just 20, exactly. So the for one, this is, while certainly not every state is just copying what California has done at all, by far, but the model that California passed with the CCPA certainly set the tenor of the conversation and oftentimes set the scope of the conversation as the other states considered their versions. And so it's not very frequent that we've seen states go beyond what California has passed, and California with the CCPA had a GLBA exemption in it. So I think that it's important to sort of constantly consider the political realities that the California advocates were facing when they were passing the CCPA, or for example, when we were advocating for and sponsoring the California Delete Act, that we included a GLBA exemption and an FCRA exemption, in order to get the thing passed. And also, as Sarah mentioned earlier, we wanted it to work we wanted the Delete Act to nestle besides the CCPA and fill the gaps of the CCPA. Not to get on a tangent here, but one thing that Sarah raised, I do want to specifically object to, which is that she raised the idea that no other state law has a delete
Emery,
right.
we just have about
I'm sorry.
5 more minutes. So if you could be
Understood.
quickly brief, because I think we'd love to get
Yes.
Heard from
balance.
Emery,
Yeah.
we heard from Ryan.
Yeah.
It would be appropriate to have the counterpoint, just to find some balance.
Yeah, no.
And then go backwards.
Of course.
We could go back. Let's just hear from Rick and Sarah. Yeah.
If
Okay.
I the counterpoints to a few comments that Ryan made, I think one thing we need to keep in mind, we keep using the term data brokers. Data brokers do this. First of all, the definition of data broker in Vermont includes a bunch of different types of businesses. Data broker is not like the term telecom, where you're all doing the same type of business. So you're using different types of data and you're a different type of business. So you can't just use one size fits all with the term data brokers are doing this, because there's different regulations. For example, what CRAs are doing with the information, and we're considered a data broker, and the federal laws that we have to follow versus a data broker that's simply collecting marketing data, right? So I think we have to be really careful when we use that term data brokers, and that it applies across the board. Second, to note, there was conversation about big tech and saying, well, it's not just Meta that would be sued. You should know that Meta, Google, Amazon are not considered data brokers and would not be applicable to this bill in any way, shape, or form. It would only be applicable in your comprehensive privacy law. So I just wanted to make sure we were clear there. Also, I think it's important to note states are actually data brokers, because you're large data
We appreciate
aggregators.
that.
And why Brian was saying, and I would agree, none of us sitting here who represent corporations would say with 100% certainty that we can't ever be breached, because we would be lying to your face.
We've already have
States can't make that comment either. But to Ryan's point earlier that said, a PRA, you shouldn't throw the PRA simply because there are bad actors who abuse it. Well, I think you shouldn't just simply do the same thing to data brokers. There may be dark web data brokers who are doing bad things, but we shouldn't simply assume every data broker is a bad actor.
If we made the Secretary of State's office hold people's delete requests, they would become a data broker, and they would have to spend a minimum of $8 million on a system that was secure from at a minimum from what they believe would be a private
and we'll
right.
have David in next week so we can chat about this.
Well, I mean, now people were saying it puts too much on the consumer to do the delete.
Oh, at the moment, it's,
on
and
their
Randy
own.
raised last week, it's just.
But if we create a system for people to have their information held to then be searched and deleted, we would be.
The drop mechanism does not hold personal information, just to be clear. The drop mechanism doesn't do that. It hashes the information that is provided by consumers. So it's held in entirely encrypted, gobbledygook that the agency can't touch. It's not actually identifiable. What the brokers then do is that they check their own systems against those hashes. And so I'm not sure if that actually is correct.
How much did it cost for California to create their system, and what are the security provisions that we would need to meet to create the same system?
Well, I know that the
Also,
agency
Chris,
has
where
those numbers
your
available.
money for
but-
your nonprofit comes from.
Oh, I'm sorry. Is there? Art?
but
I can answer those
yeah, I
questions
can
if you
send
like,
that
but that
to our
feels kind
network.
of combative.
But
and
you had a
unrelated.
question about immigration and data and
I did. I didn't want to interrupt. I was just
yeah. So I just
confirming that the state has said they would be very scared of a private right of action because of all the portals and systems we have that maintain
we haven't
a
had
lot
this
of data.
We haven't had Vermont. Wait,
And you would have
So
to have,
we have to have ADS in.
you would have to have a lot of data in order for companies to be able to authenticate the requests, right? To ensure that the Mary Smith who lives at 211 Vermont Avenue is the one who's making the request and not a Mary Smith somewhere else.
Right.
So there would be a large amount of data somehow in order to authenticate those delete requests.
Can I just make a point out? It's
Yeah.
been used twice. Data broker is defined as a business or unit of a business. And
Right.
business is defined as a commercial entity. The state is not a data broker under this law.
Correct, but I'm saying in terms of being a data aggregator and doing the
So I'm
same
just
thing,
saying
it could
the
be.
liability of the state, which is what I just heard.
right. It is
State is not a
not
data
defined as a data broker.
We,
Correct.
every time we've had this conversation, the question has been who should be exempt, and utilities are a business. I mean, I don't know.
Utilities have data directly from their clients. So they're not
It's
data
different.
brokers.
It's slightly different.
They
I don't know.
they're only data brokers if they have data of people who are not their customers, who they do not have a direct relationship with. If they have a direct
Exactly.
customer and they acquire a huge amount of data from data brokers about that customer, still not data brokers. If they sell their own customers' data to other people, still not data brokers. It's only if they have people who are not their customers' data that they become data brokers.
So
Well, and
Right.
But the same thing
Right.
that a data broker does, you
Right.
right.
cut that out in order to get that across
Right.
the
And-
finish line. It's arbitrary in the way it's defined.
Exactly. And I think that kind of highlights the point, right? Just someone can have a direct relationship. They could be amassing large amounts of data. They could be selling that data. And they're not a data broker, right? They would not be required to be registered. They would not be required to process a request under the California Deletion Act. And to address, some of the earlier comments, and I very much appreciate Brian's comments, appreciate the comments were made. And I think, broadly, we're all in alignment on consumer protection, right? It's just a question of what's the best way, right, to do that. And just to kind of hone in on one of the examples that Ryan gave, you could have a scenario, as you mentioned, somebody makes a deletion request, there's later a breach, that data is used and for identity theft, right? Well, the flip side of that is somebody's data is deleted, right? Because it was not an exemption. Their data is not there to protect them from fraud, to verify their identity stolen, and you end up with that problem, right?
But California has figured out how to do that so that you don't. You don't delete. Have they?
Well,
Is that-
yeah.
Madam Chair, just for the
Yeah.
record, I think we would, and what we have urged is to align this bill with California, because we would argue that they have figured it out. Nothing's perfect, right? But this bill is not consistent with California in its approach about the data that is exempt from that deletion request. But GLBA, as Emery testified to, that they were supportive of California, GLBA, FCRA, those are the exemptions that we would be
Right.
looking to add to this bill.
But interesting. No, I know that that's your request, but I also think I heard Ryan say that that the GLBA exempting GLBA didn't get us as far as we think it does. Is that correct?
Well, again, GLBA data brokers are generally not financial institutions for the purpose of GLBA. GLBA covers things like banks who are not data brokers. So like the overlap is not really there. It would stop certain data that might be covered by GLBA from possibly going to banks. But again, Fair Credit Reporting Act is completely carved out. So all the data under Fair Credit Reporting Act, which is what traditionally banks have used to authenticate people and all that other stuff,
That's
is
already exempted.
It's already there. Yeah.
But there are third-party companies like those that I represent who banks use for their fraud prevention databases, and they are not considered financial institutions under the FCRA, and they're not considered a financial institution under GLBA, but they use GLBA data. And we're not asking for a large entity GLBA exemption, but we would be asking for GLBA data because GLBA governs exactly the principal purpose that data can be used. And it follows the trail, whether that's to a second party or third party or fourth party. GLBA continues to govern that data. So there's nothing that we can do outside of a permissible purpose to protect that data. So it's not as though it's a big bus that you can drive through an open exemption. This is a very tailored thing, and taking that away will impact consumers, fraud databases, protection in other ways. So it's a serious.
Again, fraud prevention is carved out of this law as well. So now we've heard Fair Credit Reporting Act is a problem, but that's carved out. We've heard fraud prevention, that's carved out of the law already. So I haven't heard a use under GLBA that will not be allowed to happen. I'll give you a use. Marketing. Okay, so if a company wants to get data about people they don't, know to market products to them, it's gonna be harder for them to do that because they're not gonna be able to get marketing data. I think that would be prohibited. Like people, by prohibited, I just mean if someone asks you to delete their data and you're only using it for marketing purposes, then yes, you'd have to delete their data, even if you're selling it to banks for marketing purposes. But fraud prevention,
That's
Fair Credit Reporting Act, they don't have to do the deletion.
The Fair Credit Reporting Act, with all due respect, while it does say in order to furnish a credit report in this bill, that's not an FCRA exemption. There's a lot of uncertainty in that language. What does that mean? Does that mean the database that Furniture uses to provide the information to a credit reporting agency is exempt? Does that mean the actual database that has that credit report information in it is exempt? There's all kinds of uncertainty, and there's a reason why the FCRA exemption exists the way it does in all of the comprehensive privacy law. And it's not because we put wool over their eyes. It's because we worked with consumer advocates for years in multiple states to ensure that consumers were protected, but also the FCRA was able to still be a living, breathing law that allowed us to operate where consumers received the protections that they needed. And this is not an FCRA
Right.
exemption. It's an attempt.
And we
Could I-
can strengthen that if we need to. Any further thoughts? We have like 2 minutes to go.
If I can make
I
it,
would like to, I mean, I would love to make it just a quick point that is
Emery, quick
the way
point.
that we passed this. Sorry, the way that the FCRA and the GLBA exemption was drafted in the Delete Act is, as Ryan alluded to earlier, it's not an entity level exemption, it's a use level exemption. So it's only entities to the extent that they are already covered by FCRA. Because I agree, Sarah, that one of the concerns and one of the issues here is this ambiguity around these very large brokers that are doing lots and lots of different things. And they're entities who are doing FCRA good broker stuff, but then are also turning around and doing marketing with that data. And that's the concern that we have, is that, people feel like they've lost control of their information.
Great, no, thank you. And Rick was gonna respond.
Well, they
first.
get funding from class action settlements, but their class action settlements defined as CyPres. What's a CyPres class action settlement?
Sure. So a side prey settlement is a settlement where the class of victims can't be reasonably ascertained, or that where the award would be so de minimis that it wouldn't meaningfully enrich the recipients. So yeah, we receive side prey. A lot of our funding comes from side prey. A lot of our funding comes from Rose Grants. I think all of our funding information is, of course, public.
Right, thank you.
And frequently those side prey cases are on data breaches, which is
Now we're
one of our
taking a break.
pinpoll
Yeah.
issues.
Right,
yeah, thank you. Just one last comment.
Yeah.
Kind of the comment around, unfortunately, because of the definition of data broker, a lot of companies, get caught up on that. They do, lots of different things, and we likewise are very frustrated that there are companies that are not registered that should be.
Yeah.
Right.
okay.
And we're very frustrated that companies, right, are, not allowing consumers to exercise the rights, what should be. So I think there's a lot of alignment on those fronts. But if there are any other additional questions for us, certainly happy to meet with any of the committee members as well.
Right. Thank you all. Actually, this was incredibly educational. I think we're all grateful. This is helping us wade through sift
I
through
do
this.
want to make sure we know it's some of the organizations that are advocating benefit financially from class action sessions.
And many of everybody represented in this room is testifying you're benefiting from some piece of some aspect of this world. So I get that. But for the moment, we're done. Thank you very much. We'll be back at 10 of